A lot of startups spend a fair amount of time considering the name, the reputation they're going to build in a specific name. So I think the first important thing to make sure from an IP point of view is that this name that you're going to use to build the reputation in is in fact available for use.
Welcome back to the Business Behind Your Business podcast. I'm your host, Paul Sweeney, a chartered accountant and business advisor. And today we're going to look at the topic of intellectual property. Now, many startups have told me, or people starting business have told me, that they don't need to worry about protecting intellectual property because they don't actually have any. I don't think that's the case. And there's a man on the other end of the microphone that's going to agree with me on that because he works closely with business owners protecting their intellectual property. Welcome to the microphone, André Meyer.
Thanks, Paul. Thanks for having me.
That's great to have you here because, André, you've been in this field of intellectual property for over 15 years. You're the founder of Meyer West IP. So you would have some interesting experience and stories to tell us about intellectual property, when it's done well and when it's not done well. But there are a couple of key things I think we mentioned as we were speaking before that every business owner should get in place. What would be the first starting point for anybody starting a business? What's the key thing that they need to get in place for intellectual property?
Look, I think that a lot of startups spend a fair amount of time considering the name, the reputation they're going to build in a specific name. So I think the first important thing to make sure from an IP point of view is that this name that you're going to use to build a reputation in is in fact available for use. So Paul, a thing that a lot of my clients sometimes are not aware of is that simply because you have registered your business name with ASIC does not mean that you are free to use that name in commerce. The reason being that the records of ASIC and the trademarks registry do not communicate with one another. So ASIC will basically check whether there is not another name that is basically identical to the name that the client is proposing to use and then register the business name. However, if a third party had registered a trademark for that name, then all of a sudden the client using that name may then infringe trademark rights, because with a trademark, one does not necessarily only look at names that are identical, but the Act says that any name that is either identical or deceptively similar would constitute trademark infringement. So I've seen cases where clients have started their business, adopted the name, started selling products, and then receiving a letter of demand where they clearly infringe the trademark. And so at that stage, all the effort that they've put into establishing a reputation in their trademark is cancelled, and they have to withdraw any products that they've sold or been marketing. They have to rebrand, and all the costs of developing a website, putting out collateral and marketing, all of that is then, strictly speaking, money wasted, and they start afresh. And that unfortunately we see way too often. So something as simple as adopting a name is a key part to a good intellectual property strategy.
Yeah, because I've had people tell me that, I don't need to worry about that because I've registered the business name or I've registered the domain name and I've got the domain name, so it must be okay. And that's clearly not the case.
No, that's not the case. And if anything, we are seeing people taking action against people registering domain names based on their registered trademark rights. So making sure that your trademark or the name you will be using is available for use is key. An issue we often see is that people decide to use a very descriptive name as their business name. Well, that has some value in telling people in your name exactly what you do. That is something you will not be able to register as a trademark, because in order to have a valid trademark, your trademark must be capable of distinguishing your goods and or services from others playing in the same space. So as soon as you have simply registered a business name for a very descriptive phrase, you will never own that phrase. And so others will be free to use that. So it may be somewhat counterintuitive, but rather than using a business name which is descriptive, rather spend a bit of effort in adopting a name that is quite unique and then educating your clients and the public at large on what service is rendered under that name, so that once you have built a reputation, there's some real value in that mark, and something that if you were to sell the business of in future, there's some real goodwill associated with that name, and the person acquiring it will be acquiring a valuable asset. So, and that's quite a mistake that a lot of startups make, is to think, well, we just want to have this specific set of keywords that we can put into a browser and people will come to us. Well, that may be part of your strategy from an SEO point of view. It's really from an IP point of view short-sighted to elect a descriptive.
So we're avoiding things like saying, yeah, Cronulla Plumbing or Kellyville Painting or something like that, or Joe's Painting. That's not going to be something that you can trademark.
Correct, because that's purely descriptive. So that a good example of a made-up name is something like Kodak. Prior to Kodak selling their cameras, nobody had any idea what Kodak meant. But after they had that established themselves, when you use the word Kodak, you immediately know what I'm referring to. Now, if you also use a trademark, it doesn't need to be a name that's completely made up, but using something out of its normally context, something like Apple. If I'm a greengrocer, I won't be able to register the word Apple for my goods or services, because other people need to be able, who are greengrocers, need to be able to use the word Apple. But if I'm a software or a hardware developer, then Apple is used out of context and now can become a valuable trademark because of it being distinctive and used out of context.
So it seems to me, Andre, there's a couple of areas where you could easily make a mistake in setting up your name, that you could make a few mistakes by not knowing the right areas to look. So to me, it's very, very important you get advice in this. And now, and I think one of the reasons why small business owners don't get advice is, firstly, they don't know that they need to, and we're hoping to address that today in this conversation. But secondly, where do they go, or how should they go about finding out if there's a trademark in place?
Right. IP Australia runs a database called the Atmos database, which is free for all people having an interest in adopting a specific trademark to go do searches there. So the first place to do a search would be IP Australia's database. Now, at times it may be that a person does a search and they do not locate a name that is identical, similar, and then they assume that they are free to use that name. The problem is that trademarks also extend to names that are deceptively similar. So even though your identical name may not be registered, there may be a name that is registered which is deceptively similar to yours, and then all of a sudden you will run into an issue. So as a start, I often tell clients, do an identical search, have a look at what you find. If you find that your exact name has been registered, well, then, move on, consider another name. But if you then find one that you quite like and you haven't been able to locate it on IP Australia's database, then engage us to assist with a trademark search to make sure that that mark is in fact available for use. Now, one thing to point out, and this is where it becomes somewhat tricky, is that Australia has in general two types of trademarks. You've got a trademark that is registered on the trademarks registry, and people are free to go and search the trademarks database to check if there's a registered right. Where it becomes tricky is if somebody hasn't registered a trademark, but they have acquired a reputation in that mark and they have certain common law rights in that mark. So if somebody then uses a mark and the owner of that unregistered mark believes that the third party is using the mark in a way that they are passing off the trademark, then all of a sudden you are infringing an unregistered trademark. Now that becomes very tricky. And so the best would be, at the same time as checking IP Australia's database for registered rights, is also to do what we call a common law name search. So there we will check Google, for example. We'll have a look at various websites and have a look at whether there's not somebody who may have already started using a specific phrase or name you are proposing to use and have acquired certain rights in that name. And so, even though they may not have registered it, you may run into difficulty because they are using this mark as their brand and their trademark.
Yeah, so it's interesting that these things happen, and I guess it highlights the need to take a few extra steps in setting up. Because I know when you're about to start a business, you're excited, you just want to get it done, so you jump on board. And you'll skip those steps, those preliminary steps of checking that the name is actually available and you're not going to infringe. So well, it is important. I've had some recent experiences with some business owners we've been working with where at first glance all the searches seem to be right, but then when we've delved into it further, we've found that it is actually a breach of a trademark. So they've had to go through and rename the whole entity. Fortunately, they hadn't invested in any marketing or advertising, so they were quite early in their stage. But it's still an additional expense to go through that exercise. And you just don't want to be in that situation because as a startup, cash is in short supply, so spend it wisely. But I think spending it wisely would be in getting the advice right at the beginning. So trademarks is one key. There's a couple of other areas that business owners have stumbled on, and one is this whole idea that you mentioned about you're coming up with an idea, a new concept, and I think we call those patents. Is that correct?
Correct.
So what exactly is a patent?
Right. So, whereas a trademark protects a name that you use as your badge of origin in trade, a patent is a right granted by the government, giving you a monopoly in a specific new concept. Now, when we say a new concept, any new invention that is patentable is an invention that has not been disclosed to the public either in Australia or anywhere in the world. So the key part with any new invention, if one is looking at securing a patent, is that you should maintain the confidentiality of that concept. So often we've seen that people come to us after a few years having sold a product and making some good income from the product, then hearing from friends saying, oh, you've got to patent this. And so they come to speak to us, and then unfortunately, because the product is already in the public domain, you are no longer able to protect it. So examples of patents would be a new product. If you've got a new type of a pen that has some unique way of dispensing the ink, or you've got a new method of making a product. These are types of things that can be patented. So patents protect technological advancements. So it's really inventions that people have come up with that is an improvement on existing technology, and really they are going to file a patent application to obtain an exclusive monopoly in that invention for a term of 20 years provided by the government, wherein which they and they alone can exploit this technology. So really, if you develop new concepts and you want to ensure that all the cost and expense invested towards developing the product is protected, and so that you are able to reap the reward from your intellectual prowess, you file a patent. So a patent is a territorial right. So if you have a patent, for example, in Australia, that does not give you any exclusive rights in China. So you have to go and file patents in every jurisdiction where rights are required. But the first step is to keep the idea confidential. That is the main thing with any patentable concept, is that before you disclose it to the public, you do spend a bit of money to speak to an intellectual property attorney who will be able to advise you on the next steps that can be taken to secure a patent, to find out if there is an avenue to secure a patent, and then to consider filing a patent. Because as soon as the idea is out there, it's basically a free for all. So the general rule is that if a product is not the subject of a patent, then it's free for the public to copy. So, and that works well because if I am free to copy the product, I can compete with others and the public can then acquire the product at a reasonable price. Whereas if you've got a monopoly, you can basically dictate the cost of that product. So without a patent, it's a free for all. So if you believe there is something that you believe can be monetized, then because it's a new concept, then definitely worth exploring patentability.
So there's a couple of key things there, Andre. So it's a process. So if we want to protect that in other countries, we're going to need to register that patent in other countries as well.
Correct.
So, and look, that's something that you couldn't do by yourself. You definitely have to get the right professionals involved. But how do you know which countries, or is there a limit on what you should be doing in
Right.
terms of registering a patent?
So typically, our clients, let me quickly run through the patent process with you to give you sort of an idea of what options are available. So, the patent process will typically start with the filing of a provisional patent application. The provisional application grants you 12 months provisional protection where you can indicate to people either on your website or on your product that you've got a patent pending. Come 12 months, you then have to elect which specific countries you want to file in. So that 12 months initial provisional protection is to afford you an opportunity to test the market, whether there is going to be a demand for the product. Because it often happens that people think that they've got a worthwhile product, but after testing the market, they find that in fact the product may too be expensive or for whatever reason, there's really no demand. And so rather than investing all of this money pursuing foreign rights, you then know there's no demand. Let's look at an alternative. Or it may be that in that 12 months you find there's certain modifications required to your product, and you are then able to make modifications to ensure that you are able to have a product that in fact has some commercial legs. So come 12 months, you will then say, right, I know my markets will be Australia, and this is typically where Australian clients will look. They will look at Australia where they are based. They will then look potentially at New Zealand, and then they would more often than not look at the US and certain countries in Europe. So you can then say, well, what about Africa? What if I don't file a patent in Africa? That's all good and well. If you don't have a patent there, it just means you can't enforce your rights against third parties, but you can still sell it there. It just means that others will be able to compete against you with your own product. Now, people will say, well, what about if I know they're not going to manufacture my product in the US. They will manufacture it in China because of cost benefits in doing it there. Then one could say, look, that may be true, that it's cheaper to manufacture in China, but we know that your market will be in Australia, in the US. So if we have patent rights in Australia and the US, even though they are able to manufacture that product in China cheaply, they will not be able to export the product into those jurisdictions, for example, Australia and the US, which you have covered by way of a patent. So you really look at not necessarily where the product may be manufactured, but where are your key markets? So not even the multinationals of the world file patents in every jurisdiction. You have to decide if somebody copies me in a country like Angola, where perhaps there's not a main market for me, then I'm not going to sweat it. I can still sell it there, but I won't be have any rights. But apart from that, it may also be that it's difficult to enforce patent rights in Angola, where it's much easier to enforce your rights in those countries like the US and the UK, which have established and good, strong patent systems.
Mm. So there are steps that you can take to register the patents, but you also need to work out whether it's viable, commercially viable to register in that country, but also how are you going to enforce in those countries? And I think that's one of the barriers for a lot of businesses because they'll operate from one country. How do they know if they're being infringed on in another country?
Yeah, that's quite right. So infringement normally comes to light when you find out that your revenue is dropping on the product. That normally gives an indication, okay, where's the sales going to? But often clients who work in a specific industry, their distributors will make them aware, or their resellers will tell him, we've seen a similar product, or we've come across this, that people have asked for this product. And that's sort of when the time comes to do some investigation. Now, when you have a patent, it's not a crime to infringe somebody's patent. So it's not that you go to the federal police and tell them somebody's copying my product, please take action. It's a civil right. So when somebody infringes your rights, you as the owner of the patent will have to be required to take action if you elect to enforce your rights. Now, this is always the stage when people say, if I have a patent and I'm not able to enforce it, what value is the patent? I mean, that's a good question. It's all good and well having a right, but if you can't enforce that right, you might as well not have that right. So that's when it becomes important to remember that your patent may, over time, generate sufficient revenue that you become the person that will have the means to enforce your rights. But simply enforcing your rights or exploiting your rights personally is not the only way that you can exploit the patent. You can, for example, grant a license to a big reseller or somebody with deep pockets. And so the person who then takes that license from you will potentially be in a position to enforce your rights because they've got the financial means to enforce the rights. So it's all good and well saying, at this stage, I'm not able to, but who knows where you may be in 5 years with this invention. The unfortunate thing is you're between a rock and a hard place. If you do not file a patent application and the idea is disclosed and it goes big, you will never be able to go back and file that patent application. Whereas if you've got the patent, it may be that the patent, for whatever reason, goes nowhere, and then you've lost the money spent towards securing valid rights. But it's sort of a gambling action. If you don't take the risk of filing the patent application, you will never know. And so we often tell clients that provisional application that you file, that first step, giving you that first 12 months is of the utmost importance so that you can test the market. So in that 12 months, you really have to leave no stone unturned to see whether there's going to be a market for the product. If there is, then you know your money will be well spent in pursuing patents. If not, well, then you have to make a decision. Am I going to spend more money on this, or am I just going to say this is the end of it? But just thinking that potentially at this stage, you're not able to enforce the rights. You never know where this may be or who will be willing to come on board and take a license and pay a fee to exploit your technology on your behalf.
So there are a couple of options there, which is good to know, because I think sometimes we think that we have to do everything, but by leveraging other businesses or our customers, that we may be able to protect our interest in that way, and also the ability to license. So once you own the patent, you can license the technology to somebody else who may have a better capability to actually manufacture en masse and increase your sales. So that might be an option too. Now, you touched on, I guess, another aspect of developing intellectual property, and this is this whole idea of confidentiality and talking about not releasing it to the market. But one of the bigger risks, I think, in terms of confidentiality is, what do your employees know and what access do they have?
Yeah, very important. So companies that are involved with research and development will have a standard clause in their employment agreements with their staff that all the IP developed will be maintained confidential, and also that the IP generated by them will belong to the employer. The tricky thing comes when, for example, a company has developed some IP and they need to engage, for example, a third-party industrial designer. And so at that stage, now there's going to be a disclosure to a third party. And so it is vitally important to ensure that any such disclosure takes place under a non-disclosure agreement. So one first, before disclosing anything to a third party, make sure that you've got a non-disclosure agreement in place so that that disclosure will not count towards a disclosure to the public and then potentially destroy the patentability. But then a client may say, well, we don't develop new products. What sort of confidential information do we have? Well, very good question. One of the key parts of any business is a client list. And so one would want to make sure that an employee who leaves the employment of a company does not take with them potentially a valuable client list. We often see this when an employee leaves an employer. wanting to set up their own business, then thinking as a quick start to have an idea of clients, they take with them the employer's client list. And that is a breach of confidential information. There is an obligation on and a fiduciary duty on the employee not to take such confidential information with them. So it's key that that is set out also in the employment contract, that confidential information will not be divulged to third parties. Now, I may mention that we had a case where an employee did abscond with the employer's list of clients. And they just brutally took the client's Excel spreadsheet that displayed all of the client's email addresses. Now, what this employee did is he then copied all of those email addresses into his Outlook and sent it. But he had followed the exact sequence that our client had followed. And so with that sequence, together with the typographical errors that he had sent out, we were able to show that he had in fact stolen our client's confidential information. So that's one piece of intellectual property that companies should be very cautious at protecting. There may also be secret processes that they use in how they make sure that the efficiencies are a step ahead of their competitors. That potentially may be confidential information, not something that you can potentially patent, but something that has real monetary value because it gives you an edge. And again, something where one would need to ensure that anybody having access to that confidential information signs the necessary agreement to maintain it. So another way that employees or employers could ensure that the employees maintain confidentiality is simply not to disclose certain secret or sensitive information to employees and really control access to who in an organization will have access to confidential information. Sometimes, for example, when clients manufacture products, in order almost to maintain the confidentiality of the products, they have different entities manufacture apart. So nobody sees the whole. And so it would almost be akin to within an organization, make an informed decision on who needs to have access to certain information and limit access so that it's not just a free for all to access to sensitive information, but limit access.
Oh, that's interesting because there's more than one way that you can lose your confidential information and more than one way that you can expose your business to loss. So it's worth taking the steps to identify what your risks are and putting in place those simple steps to protect them.
Exactly. It doesn't have to involve very complex agreements that one need to have in place. It may just simply be almost common sense steps one take to limit valuable information landing into the hands of persons perhaps that shouldn't necessarily have access to that information.
So it's been really good talking to you today, Andre, because I've learned quite a bit about this myself and some of the traps to look out for clients, because I see these sort of developing with clients or potentially developing, and you just think, well, what can we do to protect the risk? But I guess we need to look at what can go wrong and what should we be protecting. So three things that you've mentioned that are very helpful that every small or every business should be looking at is your trademark protection, or whether you're infringing on a trademark before you start. Protecting your intellectual property or new processes and ways of doing things that you've developed. So how do you protect them, whether you patent them or you're secret? And how do you protect your confidential information? So three key things. That's fantastic value for anybody listening to this. So look, if you've got some value out of this, please share this with somebody else in business that should know about this, because it is vital to protect. You work hard in business, so you've got to protect it. There's no point throwing it away because you haven't taken the steps. And as we've said today, that some of these steps are very easy to implement. So look, if you do need help though, I'd always encourage you to see the right professional to help you with this. And look, if you want to get in touch with Andre, how's the best way to contact you, Andre?
Paul, I think the easiest is to contact us via email. My email address is my name, Andre, Andre, at my surname, Meyer, Meyer, West, and then ip.com.au. So it's Andre at meyerwestip.com.au.
Fantastic. We'll put links to Andre's contact details in the show notes, as well as the IP Australia search to get you started. But please don't do this alone. Get the right help, get the right advice, and make sure that you put your business on the right path right from the beginning. So, Andre, thank you again for your time today. It's been very enlightening. I hope everybody else has got as much value out of this as I have, and chatting with you potentially in the future about some of these other topics to do with intellectual property.
Thank you very much for having me, Paul.
Thanks for listening. Do you have a question you'd like our team of experts to answer? If you do, send your question to podcast@thebusinessbehindyourbusiness.com. To hear more from The Business Behind Your Business, don't forget to subscribe using your favourite podcast player. Or you can visit the businessbehindyourbusiness.com website.